Yes, ma'am.
Supplement cost is item number 1.
Wait, please, Your Lordship. My Lord, this is a petition under section 482. My Lord, the petitioner herein is aggrieved by an order dated 12/1/23. I'm sorry, my Lord, I stand corrected. By an order dated 15/6/2022, passed by the Judicial Magistrate, East Khasi Hills. My Lord, by this order, the court below was pleased to dismiss the complaint filed under section 138 CRPC by taking recourse to section 256 CRPC, my Lord, which amounts to actually acquitting the respondent from the liability of the case. Now, my Lord, the facts of the case are that there is a long pending dispute, my Lord, with regard to certain amount of money recoverable from the respondents and arising out of a commercial transaction.
Mr. Gautam,
My Lord.
respondents are here. Have you issued any notice on them?
No, my Lord. My Lord will have to admit the matter. And
Another point, I think from a reading of your petition, it appears that the impugn order was passed under taking recourse to section
256, my Lord. 256.
That's an appealable order.
No, my Lord, it's not. It is not an appealable order, my Lord.
Okay.
There is no provision, my Lord. I've gone through it. The only what we are praying here is, my Lord, our complaint was dismissed, my Lord. Once a private complaint is dismissed, my Lord, the only recourse is by filing a petition under 482 CRPC, my Lord.
Yes. 362 would come to.
My Lord.
Court counsel for the petitioner. As prayed for, let notice be issued upon the respondents the same is returnable within 2 weeks. List thereafter.
We'll take steps by registered postman. Please. Abhay.
Item number 2.
Lordship, the senior government advocate is still on a leg at courtroom number 2. Kindly let the matter be fixed at the
Who is the
bottom
petitioner?
of the board.
Who is the petitioner? None appears for the petitioner. This is matter tomorrow.
Item number 3.
Yes, miss. You have to continue.
My lord. Counsel.
Mr. Kikhan is here in this matter. I'll inform.
End of the board.
Lady Costless, item number 1.
Yes, miss. Tell me.
Your Lordship, in this case, I'm seeking one week time, Your Lordship, to file a compromise agreement.
Have the matter been settled?
Your Lordship?
Have the matter been settled or agreed to by parties?
Your Lordship. Yes, Your Lordship.
That's between you and the private respondents. The state has got nothing to do. And you are there representing the state. When a counsel for the petitioner has submitted that though the petitioner and the private respondent herein has come to some agreement on the issue involved, however, the formal deed of compromise or deed of settlement could not be filed today and has sought for some time for the same to be filed. How long?
1 week, Your Lordship.
As prayed for, this is matter after 1 week.
Highly obliged. Item number 2.
Yes, what is required here?
Lordship, the government is supposed to give the reply to our submissions.
Okay.
Because learned counsel earlier on, Mr. Senior Counsel, Mr. D.K. Mishra had made a submission that let them complete their argument, then only if it's required to go into the merits again he'll argue. As of now, our submissions are over, Your Lordship, on merits and
On merits and the issue of maintainability.
Your Lordship. Thereafter, they said they wanted to file some affidavits. That took them 6-7 months to file the affidavit. Finally, it was filed. We filed a rejoinder to the affidavit, and they're supposed to start the argument.
Yes, miss, you are in this case.
Lordship, I'm from the state, but my senior from Delhi was supposed to conduct the matter. I believe he's indisposed. Kindly fix the next date.
So we'll take it up tomorrow.
Lordship, whatever is.
Because the last order, Your Lordship, has clearly reflected that there will be no further adjournments.
Yeah, but if he's suppose maybe we don't, he couldn't get through, you know. So you see, earlier we used to say, saved by the bell. Now it's saved by the network. On pre-made by the respondent, this is matter tomorrow.
Tomorrow. All right.
Item number 3.
May I please, Your Lordship? Let this matter must become at the end of the board. Conducting consent is engaging in another court.
End of the
Item number 4.
Please, Your Lordship.
The conducting counsel, Mr. Sai, is on legs in court number 2.
Oh, you're not, I think you're only supposed to file your, who is supposed to file the written argument? Yes, Mrs. Nkon, you are in this case. So what are you doing there?
My lord, I was thinking maybe different case.
You should be attentive.
Yes. My lord, we have already filed a written argument in this case. Already concluded everything. My lord.
And the state,
State has...
they are to reply?
Yet to reply. Okay, Sai is on legs.
Oh, what are the instructions? You tell me.
Lordship, I was appearing on behalf of Mr. Sai. He was supposed to appear in this matter, but he's on legs in court number 2.
It is for the written arguments, my lord, to be filed. We have filed, I think they were supposed to file. I do not know whether they have filed or not.
Learned counsel for petitioner has submitted the written argument on behalf of the petitioner has been filed. The state respondent, only the state respondents are here?
My lord.
Any private respondent?
No, my lord.
On behalf of respondent number 3, my lord.
Who's respondent number 3?
My lord, Ministry of Health and Family Welfare.
But are you
We don't have a direct.
are you represented by the state council or?
The state is representing us, my lord. We have a very limited role over here, my lord.
Fine. If the state is covering for you, then that's okay. As prayed for, let the reply to be filed by the state be filed before this court within the next date fix. This is matter to 2 weeks. Obliged.
Item number 5.
So the petitioner is no longer represented, and the previous counsel is also not here. I think she was, requested to inform the petitioner by the previous order of this court. It transpired that the petitioner is left unrepresented on account of the fact that the learned counsel appearing for him has disengaged herself from the matter. The counsel was, however, requested to inform the petitioner of the same and for the petitioner to take necessary steps in this matter. However, none has appeared on behalf of the petitioner. Under such circumstances, what is to be done? Yes, Mr. Nobri, can you tell me?
So normally, if the counsels are not appearing anymore, notice will have to go to the petitioner.
But who is to issue the notice?
High Court.
So the registry. I had thought of
He
that.
can engage another new counsel.
As submitted at the bar, the registry is directed to cause notice to be issued upon the petitioner, informing him of the change circumstances. Let this matter appear 3 weekends.
Item number 6.
What is this matter about, Mr.?
My lord, this is with regards to the compulsory appointment, my lord.
Okay. Or he is to file that list.
My lord. list as well as the what is the
what is the
development in
development?
that withdrawal of that notification, my lord.
Okay, there was some remark. Isn't
My
it?
lord.
Mr. Debnat is supposed to appear.
Yes, my lord.
He is here.
I have not seen, my lord.
Whether he's in the other court or it's up to you. Whether we wait at the end of the vote or should we?
My lord, I have not seen him today. His room is also locked.
Mr. Archa appears for the petitioner. However, the respondent is not represented by the learned CGC. Accordingly, as submitted by the learned counsel of the petitioner, this matter is adjourned. List is same after 1 week.
Item number 7.
Please, Your Lordship. Lordship, I pray for some more time, Your Lordship, in this matter.
Therefore,
The petitioner, Your Lordship.
you for state,
For the state, Your Lordship.
as prayed for by the learned counsel for the petitioner, list this matter up to 2 weeks.
Highly obliged, Your Lordship.
Item number 8.
Yes.
This is a criminal petition for quashing of some proceedings, Lordship, from Cleariat Court. Pending since 2020.
So what is the issue involved?
Issue is, Lordship, this is a partnership firm. It's against a cement company in Cleariat. They had ordered some grinding balls from us. Then we had supplied those grinding balls. They had paid some money to us. Then they issued us some post-dated check for the balance amount. When we approached the bank for withdrawal of those amount, then the check bounced. Then we file a 138 proceedings in Raigad Court. Against that, some notice was issued. Against that, they filed an appeal before the Session Court. That appeal was dismissed. Now, in the meanwhile, after 3-4 years, then they file a criminal complaint against us in Cleariat Court. Then bailable orders was issued. Thereafter, non-bailable orders was issued against us. We never had knowledge of the same. That is why we are before this court now, saying that these are all civil disputes. And your Lordship, on many occasions, had granted time also to settle the matter, but nothing positive had come forward from their end to settle the dispute.
Okay. So we'll hear the matter.
May it please, Your Lordship. Petitioner here, Your Lordship, is a registered partnership firm. In the year April 2016, we had purchase order 21/3/2016, Your Lordship. The respondent had placed from our firm for supplying of grinding media balls to the factory to a tune of rupees 55,36,687, inclusive of excise and CST. Thereafter, Your Lordship, on 31/3/2016, the aforesaid order was so placed. The respondents being a financial security, Your Lordship, issued post-dated checks from the bank, IDBI Bank, in favor of our company, of our firm. Now, those post-dated checks, can you see, Your Lordship, is at page 3. Page 3 of my petition, and the annexures are at annexure 2.
Page Page
These are the purchase orders and checks that have been issued to us, Your Lordship. Page 13.
13.
Annexure 2 is the purchase order, Your Lordship.
Yes.
And Annexure 3 series.
These are the
Three
checks.
series are those demand drafts, Your Lordship.
Demand draft.
Post-dated checks, sorry, Your Lordship. Post-dated checks. 3 series, 14 and 15.
Yes.
Now the firm, on seeing that they've given us post-dated checks, they were feeling secured, saying that okay, we'll supply you these materials what you have ordered from us. So, Your Lordship, what happened is that on 9/5/2016, the company, the respondents herein, made a part payment of 5 lakhs, which is at of 5 lakhs. Thereafter, they stopped making the payment. Now, all the goods were already supplied to them.
What is that? Government of 5 lakhs?
That is not there, but it is admitted that they paid us 5 lakhs out of the 55 lakhs. Thereafter, they stopped making some payment.
Yes.
Then we had emailed them, Your Lordship.
Yes.
That is Annexure 5, Your Lordship. Page. Annexure 5, page 23. I may be permitted to read, Your Lordship. With reference to your supply of grinding media ball to our company, we would like to inform you that an amount of 5 lakhs is already transferred to you via RTGS on 9/5/2016. Regarding the balance amount, we would like to inform you that our cement manufacturing unit at Meghalaya was badly hit by a heavy cyclone during last week of April 16, making a huge damage to our plant, because of which our unit was under shutdown for almost a month. This ultimately fully disturbed our cash flow position, and we had to face acute financial crisis during this period, for which we are not able to clear the post-dated checks issued to you. Presently, the plant operation system is restored and our production has also come to a normal stage. Therefore, we have come to know that our plant technical team, that the quality of materials received from you is not up to the mark. Copy so-and-so, Your Lordship, for which you are requested to compensate the loss. However, based on the fact mentioned above, we would further like to inform you that, as directed by our CMD, we are going to clear your dues within a period of 2/6/2016 to 15/7/2016 on an average of 7 to 8 lakhs on weekly basis through RTGS. So they made a commitment to clear the balance amount.
Yes.
Then, Your Lordship, on 7/6/2016, they made another part payment of 3 lakhs.
On which date?
On the 7/6/2016. Now, Your Lordship, now the total amount out of 55 lakhs they've paid us is 8 lakhs.
Yes.
Thereafter, Your Lordship, no further payment was made to us. Then the officials of our firm, Your Lordship, then on 26/2016, deposited all those post-dated checks. 26/2016, before the Union Bank of India, Raigad branch, with the hope to recover all the amount that the respondent was due to us. Now, the bank informed us that the aforesaid checks have bounced for insufficient balance. Then, as the procedure, Your Lordship, then we issued them legal notice that within 15 days, If you don't reply to our legal notice, then we'll have to proceed accordingly in accordance with law. Then, Your Lordship, after expiry of the 15 days, then we were compelled to file a criminal complaint case on 7/9/2016, file a criminal complaint case under Section 138, Your Lordship, of the NI Act 1881. Thereafter, the court, by order dated 9/5/2017, registered the case against the respondents and its directors.
Yes.
Now, being agreed by that order passed 9/5/2016, whereby a case has been registered against them, they filed a revision, Your Lordship.
When was your case filed? On
9/5/2017.
You filed on 9/5/2017?
Yes, Your Lordship. 9/5/2017. On the same day it was registered.
Okay.
Being agreed by that order 9/5/2017, Your Lordship, they filed two revisions, because, Your Lordship, two revisions before the Court of the Additional Session Judge, Raigad. In one of the revision, being revision number 161 of 2018, the respondent and one of its directors, namely Adarsh Tujunwala, were petitioners, whereas in the other revision, being criminal revision number 162 of 2018, the remaining directors of the respondent company were petitioned. Now, the Additional Session Judge, Raigad, Your Lordship, after hearing both the parties on 7/9/2019, dismiss both the revisions, Your Lordship. Those are at Annexure 7, 8, and 9, Your Lordship.
First indicate the page, then you
Page 27, sorry, Your Lordship. Annexure 7 is the revision which they have filed, Your Lordship.
And the order?
The order, I'll take Your Lordship to I'll take Your Lordship to page 60. 60. Page 60, Your Lordship, Annexure 9. Annexure 9, Your Lordship, page 60, the relevant portion.
Yes.
Paragraph 10. In the results, the revision does not succeed and stands disallowed. The impugned order 9/5/2016 passed by the trial court is hereby confirmed.
Yes.
Now, this order, Your Lordship, was passed
Yes.
on 7/9/2019, Your Lordship. Now, the respondents herein, left with no other means, what they did was they filed a complaint against us, Your Lordship. Complaint petition in paragraph 10, I'll read, which is more relevant, Your Lordship. Paragraph 10, page 6 of my criminal petition. Paragraph 10.
Yes.
As a countermeasure against the aforesaid complaint case filed against the respondent and its directors, the respondent on 3/10/2018, after more than 2 years after the supply of goods to the respondent, filed a complaint case being CR case number 3 of 2019 under section 200 CRPC before the Additional Deputy Commissioner, East Jaintia Hills District, against the petitioner, alleging inter alia that MS Milton Alloy Casting Co. had supplied grinding balls of inferior quality to the respondent, and that MS Milton Alloy Casting Company refused to place all the grinding balls supplied to the respondent as agreed in the sale purchase terms. On the basis of the above, it was alleged that the petitioner had committed an offence of 406, 418, 420, 422, 425, 427 IPC. The aforesaid complaint case 3000 was initially endorsed to the Court of B. Khashandi, Assistant to Deputy Commissioner, East Jaintia Hills, Meghalaya, for disposal. The said court on 3/10/2018 recorded the statement of the representative of the respondent's company and thereafter directly issued a bailable warrant of arrest against the petitioner. I'm reading this because it's very relevant, Your Lordship, before I go into the grounds. That although the petitioner did not have any knowledge of the bailable warrant of arrest, however, the London Trial Court on 28/11/2018, on mere submissions of the counsel of the respondent that the petitioner failed to appear before the court in spite of bail warrant of arrest being served on him, issued a non-bailable warrant of arrest against the petitioner and fixed next date on 8/2/2019. Thereafter, a non-bailable warrant of arrest was never executed and the said complaint case was never taken up by the trial court. It was only on 28/8/2019 on an application of certified copy of some persons that the said case was re-endorsed to the court of Shri S. Marweng, Assistant to Deputy Commissioner, East Jaintia Hills, for disposal. Thereafter, the said case has never been listed till date. The petitioner was unaware of the criminal complaint being CR 3018 that was filed against him. But it was only on 9/4/2019 that the respondent and its directors approached the petitioner for settlement of the complaint case filed against them under 138 Negotiable Instrument Act 1881. That the petitioner came to learn about the criminal complaint. Thereafter, after the efforts for settlement failed, the petitioner engaged counsels to pursue the CR case 3018, after which the certified copy of all the materials of the said case was procured on 8/1/2020. Now, Your Lordship, the facts of the case is that we had supplied them materials. They have committed to pay us. After supplying of all the materials, they had failed to pay us the balance amount, saying that because the factory was hit by a cyclone, which they have admitted, and thereafter they made the commitment, they paid the balance amount. Thereafter they paid only 3 lakhs. The balance amount was never paid. And they even committed to us by issuing us post-dated checks. We were financially secured, saying that they're paying us. And now when we went to withdraw those amounts, the bank indicated to us that there was insufficient balance. So there was a motive on their part in not paying us the amount. Instead of coming to a settlement or pay the amount, after they failed in the 138 appeal before the Raigad court, they came and filed a complaint case against us, saying that the materials are not up to their satisfaction. Now, Your Lordship, my humble submission is that whatever the complaint filed by them against us is just a counterblast against the NI proceedings which we have filed against them. And Your Honor, Your Lordship, kindly appreciate the fact also the dispute in question is a civil of nature. Either you approach the consumer court for the deficiency in service, or approach the civil court for redressal of their grievances. Now, what the respondents here and now they have directly approached just to harass us before the criminal court in Crieriat, whereby the criminal court Crieriat also has directly issued a non-bailable warrant of arrest against us without our knowledge, and was never executed. Case has never pursued. It was only after we applied certified course, then we got some information. And after when they came to us also for another settlement, that failed, then only we came to learn that there was a criminal case pending against us. So my humble submission is that the entire process is a abuse of process of court, Your Lordship, just to escape the liability which they are liable to pay us, Your Lordship. And the sections in the complaint case, nothing attracts, Your Lordship, that we have cheated them also. 406, 418, 420, 422, 425. And whatever orders passed by the trial court, Your Lordship, is without application of mine. Your Lordship, I'd like to place some judgments.
Mr. Nombre, what would constitute abuse of the process of the court?
That, Your Lordship, is because the proceedings are pending before the Raigad court. They ought to have proceed with those matter, make out your grounds there. Instead, they went and filed a criminal case against us. That amounts to the abuse of process of court, Your Lordship. Multiplicity of proceedings.
That is the factual aspect. But what about the legal aspect of it, or rather any judicial pronouncement on this point?
Your Lordship?
Where some parameters are laid out.
I'll lay down, Your Lordship. I have enough judgments, Your Lordship.
Okay.
Your Lordship, 2020, Your Lordship, very recent.
2020, what's the citation?
2020, Volume 3, SEC 240. Paragraph 6, 7.7 and 8.2, Your Lordship.
Have you given them a copy of your list of books?
I have not, Your Lordship, because this matter, whenever it's been taken up, Your Lordship, they've asked for time.
They should not be caught by surprise. They should
I know, I've got
be able to refute at least the legal points.
Whenever you come prepared, the matter's not taken up.
Yes,
Para 6, firstly, Your Lordship.
Yes.
Considering the averments and allegation in the FIR and even the charge sheet, the main allegations are that the company, namely so-and-so, supplied substandard materials, runner buckets, turbines, and the supplied runner bucket turbines were not as per technical specifications. It is also required to be noted that there is no FIR complaint charge sheet against the company, so-and-so, and the appellants are arraigned as an accused, as a managing director, so-and-so limited respectively. From a bare reading of the FIR and even a charge sheet, there are no allegations that they are fraudulent and dishonest intention to cheat the government from the very beginning of the transaction. Even there are no specific allegation and averments in the FIR charge sheet that the appellants were in charge of administration and management of the company, and thereby vicarious liable. In the light of the aforesaid, the prayer of the appellants to quash the criminal proceeding against the appellants for the offence under 420 is required to be considered.
No proposition is laid down here.
Now 7.7, Your Lordship. 7.7. In Inder Mohan Goswami versus State of Oriental, it is observed that held by this court that the court must ensure that criminal prosecution is not used as an instrument of harassment for seeking private vendetta or with ulterior motive to pressurize the accused. It is further observed and held by this court that it is neither possible nor desirable to lay down an inflexible rule that will govern the exercise of inherent jurisdiction. It is further observed that and held that inherent jurisdiction of High Court under 482 CRPC, though wide, has to be exercised sparingly, carefully, with caution, only when it is justified by the tests or specifically laid down in the statute itself. Now 8.2, Your Lordship. It is also required to be noted that the main allegations that can be said to be against the company has not been made a party. The allegations are restricted to managing director and the director of the company respectively. There's no specific allegations to constitute vicarious liability, even the vicarious liability. In Maksud Said versus State of Gujarat, it is observed and held by this court that the penal code does not contain any provision for attaching vicarious liability on the part of the managing director or directors of the company when accused is the company. It is further observed and held that vicarious liability of the managing director and director would arise provided any provision exists on that behalf in the statute. It is further observed that statute indisputably must contain provision fixing such vicarious liability. It is further observed that even for the said purpose, it is obligatory on the part of the complainant to make requisite allegations which would attract the provisions constituting vicarious liability. In the present case, there are no such specific allegations against the appellant, being the managing director or director of the company respectively. Under circumstances also, the impugned criminal proceedings are required to be quashed and set aside. Now, this decision, Your Lordship, I'm relying upon is with regard to specific allegations. In a complaint case which they are filed again as Your Lordship, there's no specific allegations against the director. This is the decision which I'm relying on that ground. Now, the next decision is with regard to civil nature, Your Lordship. This is 2020, Volume 16, SCC 714. This is with regard to civil dispute. Paragraph 6.1, Your Lordship.
Yes.
We have perused and considered the allegations made in the complaint as well as the order passed by the trial court taking cognizance against the accused. At the outset, it is required to be noted that summons have been issued against the accused for the offence under Section 323-41379 IPC. Having heard the learned counsels appearing for respective parties, and even considering taking the allegations in the complaint as they are, we are of the opinion that initiation of criminal proceedings against the accused is nothing but abuse of process of law and the court. A purely civil dispute is tried to be given in the color of a criminal dispute. Now, Your Lordship, it's another decision, Your Lordship. This is with regard where the proceedings are quashed when civil remedies are available, Your Lordship. This is 2018, Volume 13, 374, paragraph 12 and 13.
Yes.
After going through the allegations contained in the complaint and the materials on record, we are of firm conclusion that the matter entirely pertains to civil jurisdiction, and not even a prima facie case has been made out for the offences of Section 420, 406, 409, which is the same sections which they have filed against us, Your Lordship. Read with Section 120B IPC, even if the allegation contained in the complaint are to be taken on the face value. The complaint gives a clear impression that it was primarily a case where the respondent had alleged breach of contract on the part of the appellant in not making the entire payments for the services rendered to the appellant. On the other hand, it's not a dispute that substantial amount have been paid by the appellant to the respondent company for the services rendered. Reasons for non-payment of the balance amount as given by the appellant is that the services rendered by the respondent company were not in terms of the agreement entered into between the parties and were deficient in nature. For this reason, even the appellant have filed claim against the respondent company alleging that the appellant suffered losses because of defective services provided by the respondent. You know, this is a case which squarely covers my case. It's a breach of contract.
Yes.
And the entire dispute is of civil nature.
When you have supplied the materials, is there any certificate of, as regard quality control, so on and so forth?
No, they've taken the material from us. The entire quantity was taken with them.
And
now, after they stopped payment, they came up with an excuse.
Was it utilized?
Your Lordship?
Was it utilized? The materials that were supplied to them?
Because we've already supplied to them. On being satisfied, only they took the equipment, then they paid us with space-dated checks. Now, when they failed to pay us, they said there was a cyclone that has hit the company, then was shut for 1 month. Realizing that they cannot pay, they come up with an excuse that there's some deficiency. Even if there's a deficiency, there is a remedy for them available, not to file a complaint case against us. And they feel in the appeals also before the revision applications before the lower appellate court in Raighat.
Between the time that you have supplied the materials to them, 2016, and the date on which they filed the complaint was?
2018.
2018. 2 years have passed.
2 years. The humble submission is that entire proceedings now pending before the Cleariat Court, Your Lordship, that is to be quashed and set aside. That's my prayer, Lordship.
Yes.
Please, Your Lordship. Lordship, may I take your attention to Annex 5, Your Lordship.
Yes.
Lordship, may come to, on the first paragraph, come to 8th line, Your Lordship. Lordship, may I read, Your Lordship?
Please.
Further, we have come to know from our plant technical production team that the quality of the material received from you is not up to mark, for which you are requested to compensate the loss. Lordship, even after we have sent this email also, no action was taken again by them. Lordship, I may take your attention straight away to Annex 10, Your Lordship. Page 63, Your Lordship.
Page
63. 63. Lordship, this is criminal complaint filed by us.
Yes.
For the Learned Trial Court at Cleariat, Your Lordship.
Yes.
Lordship, I may take to para 5.
Para?
Para 5, Your Lordship. Page 64, next page.
Yes, please.
That upon receipt of the grinding media balls, the same were changed at the cement plan, the same were charged at the cement plan of the complainant on 12/5/2016. But to dismay of the complainant, after only 8 hours of running, the media balls they were found to be inferior quality, and around 60 metric ton of the media balls were found to be in broken condition. Thereafter, further, it's pertinent to state that as per the terms and conditions as per the terms and condition of sale and purchase dated 11/03, as supplied by the accused person, the sale and purchase term states that breakage of more than 5% of grinding media accounts for a free and full replacement of all the media balls. Then next para, Your Lordship, that upon noticing the daily breakage of the grinding media balls supplied by the accused person, the complainant had sent several emails to the accused person representative via email dated so and so, apprising him of the fact that the media balls so supplied are breaking on a daily basis, hampering the production of the complainant, and thereby huge loss is incurred upon the complainant. The complainant also called upon the accused person representative to compensate a portion of the losses suffered by the complainant. And next para, Your Lordship. Thereafter, and so, a joint inspection was carried out. A joint inspection was carried out at the cement plant of the complainant at Wajar Narpo village, Iskil district, Meghalaya, between the representative of both the accused person and the complainant, and the minutes of the meeting in connection to the aforesaid joint inspection and meeting was thereupon prepared, and over and above the said meeting and inspection the representative of the accused person had concurred that they will decide regarding the media balls. Next paragraph, Your Lordship. That even after the joint inspection, the accused person takes no steps to replace the broken media balls, and no response was given from the accused person, to which the complainant again sent an email to the accused person representative calling for another joint inspection, replacement of broken media ball, and compensate for a portion of loss. Thereafter, Lordship, para 9, Your Lordship, that despite repeated emails being sent to the complainant by the complainant to the accused person representative, no action or recourse was taken by the accused person, and thereupon the letter dated so and so was sent to the accused person, apprising the accused person of the promise of 200% assurance given by the accused person prior to purchase of the media balls, the breakage of media balls so supplied. The joint inspection concluded, calling upon the accused person to comply with the terms and conditions as mentioned in the letter dated so and so, and to compensate for the loss suffered due to faulty grinding media balls. We have made, as you can see from the complaint before the Learned Trial Court, we have made several communication for them to compensate, and several one joint inspection also was there by the representative from the petitioner companies and from our side, Your Lordship. But since no conclusion could come, Your Lordship, because thereafter the meeting also they didn't do anything to compensate or replace the broken media balls. And Your Lordship, I must say that, Your Lordship, the proceeding before the Learned Trial Court is at a very premature stage, Your Lordship. Your Lordship, we may take Your Lordship to section 244 of CRPC, Your Lordship.
244?
244, Your Lordship.
444 or 200?
244, Your Lordship.
Yes.
Evidence for prosecution. When in any warrant case instituted otherwise that on a police report the accused appear or is brought before a magistrate, the magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution. Then Your Lordship may come to section 245, Your Lordship.
Yes.
When accused shall be discharged, if upon taking all the evidence referred to in section 244, the magistrate considered for reasons to be recorded that no case against the accused has been made out, which if unrebuted will warrant his conviction, the magistrate shall discharge him. That's what I'm submitting here is that what the facts have been placed before Your Lordship, this can also be placed before the Learned Trial Court, Your Lordship, because the proceeding there, Your Lordship, is at a very premature stage, Your Lordship.
Your statement has been recorded?
Yes, Your Lordship.
Excuse me.
Lordship, petitioner herein has not made appearance before the Learned Trial Court till now, Your Lordship. That's why the Learned Trial Court issue BWA and NBWA, Your Lordship.
Excuse me. Anything else?
Yes. Lordship, so far as the 138 proceeding before I got is separate proceedings. It has nothing to do with this proceeding before the Learned Trial Court at clear, Your Lordship. Lordship, which is why this application need to be rejected and sent back to the trial court.
Yes.
No, one small reply. But you've read paragraph 5, 6, 7, 8. Paragraph 5 it clearly states that on 12/5/2016, they realized that there's some deficiency in the grinding balls. 12/5/2016 is the cause of action. If they have to file a criminal case against us. Now, when they have filed a criminal case, after 2 years, more than 2 years, in fact, 2.5 years, they filed in 2018 in the month of October.
Lordship, it was
Can
this
you
year
see
there
also
was
in
a communication between our
Just-
company and their company, Lordship.
This is all 2016 communications. As an afterthought to harass us, that's why they filed. And looking into the entire facts of the case also, it's purely a civil dispute. If there's any deficiency, consumer court is open for them to go and address the redressal, not by way of a complaint. They're trying to paint the entire case, they're trying to paint a color of a criminal case. But in fact, it's a breach of contract, it's civil of nature.
Yes.
All the paragraphs they have read is about 16, 17. What took them so long to file a criminal case against us? And even the ingredients also does not attract criminal case. The facts itself are totally in civil nature, Lordship.
Lordship, whatever submitted before your Lordship, they can also submit before the trial court, your Lordship. And during this time, Lordship, before filing a complaint, we were in communication with them,
482, your Lordship,
which
inherent
compelled us to
powers.
file a complaint before the learned trial court at Clear, your Lordship.
Now they're saying that.
But why have you not appeared before the trial court?
Well, we had no notice. I've read paragraph. I've informed that we had no knowledge how it was done. Then only when they came for settlement with us, they said, "Come, we'll agree." Then when the talks failed, then we came to learn that the criminal case has been filed against us. Then we procured the certified copies and directly.
But even then, you see, as soon as you came to know that there's a proceeding against you, or rather a complaint filed against you, you should have approached the concerned court with a suitable application. You have not done that.
That we have not, but Your Lordship, under 482, Your Lordship has the power, Lordship. That's why we've come before this court.
Of course, the court has the power, but it's incumbent upon you to first. It's logic. First, you have to redress your grievances at the point of origin. Thereafter, if some impute order is passed or otherwise, procedure has been initiated against you, which is illegal or irregular, then you can approach this court.
On that count, Your Lordship, let it come on Friday, on Monday. I'll take instruction why. Maybe the court also was not functioning because it was a. Your Lordship.
To that, this petition.
That's why I made a statement that the case did not proceed henceforth. Before in my
As Your Lordship is aware, the provision of section is 482 is used in a very sparing manner, Your Lordship. And proceeding before the learned trial court is at a very premature stage, Your Lordship.
That is true, but we made a specific statement that the case is not proceeding, Your Lordship.
That cannot be the
So
ground.
you have to substantiate on that.
My humble submission, Your Lordship, it's a civil
Whatever the
nature.
case may be, it's incumbent upon you to first approach you cannot expect the High Court to take upon itself every matter under the sun.
But looking at the nature of the case, Your Lordship, it's totally a breach of a contract. It's a civil nature. It's a case where they can go to consumer court. This is a counterblast to the NI proceedings we have filed against them.
That is a very.
That is why, Your Lordship, we've come before this court.
True, but you can also you see what are the High Courts for? It's only when you have exhausted your remedy, then you come to the High Court. Otherwise, you see there are the hierarchy of courts as we have.
I totally agree, Your Lordship. Look at the manner in which the complaint has been filed, Your Lordship. That is why we're before Your Lordship.
Even then, that as has been.
They have the remedy also. Is that the remedy for them to file a complaint and harass us before the?
Anyway, you come back on 17 on Friday. Eh?
On Monday, Your Lordship, on Monday.
Monday.
I'll get instruction. Why was the court not functioning and? Please. What really happened? What really transpired?
What really compelled you to come before this court?
Your Lordship.
Heard learned counsel for the parties. However, on a query by this court, the learned counsel for the petitioner has submitted that he may be allowed to take instructions and to apprise this court accordingly. As paid for,
A week, Your Lordship. Maybe it'll take some time also.
This is matter to 1 week.
Yes.
2 weeks, 1 week.
A week.
This is matter to 1 week.
Oblige.
Item number 9.
Yes, who's appearing here?
Your Lordship, for the state, Mr. S. N. Gupta is there, Your Lordship.
For the state?
The state, Your Lordship.
State is a respondent here.
Your Lordship, state is a formal party. It is a dispute between two private parties, Your Lordship.
Apparently, it appears none has appeared on behalf of the petitioner, as well as the respondent number 1. Oh, you have to respondent 1. None has appeared on behalf of the petitioner. Respondents are however, represented. On submission made, list this matter after 3 weeks.
Item number 10.
Lordship, I pray that this matter be taken up after 2 weeks.
You are for?
Petitioner.
The respondent or APSC.
On prayer made by the petitioner, not objected to by respondent. List this matter after 2 weeks.
I oblige, Your Lordship.
Item number 11.
Right. On the last date, I was asked to give my written argument. So I'm filing my written argument. What was left over is that I was the list of dates were supplied by the
mostly on the issue of delay.
delay, principally on the delay.
As to who is
Who is
responsible.
attributed. It was pending for 17 years. So then the court had asked for supplying the written argument. I think they have supplied. So today I'm filing my written argument as well as given the copy. I think
You've already filed yours.
I have already.
So nothing's left.
Nothing
right?
left. Principally, it is on the basis of that the interest, besides other ground, but basically is the interest portion.
Interest portion.
Yeah, other aspects have been virtually covered because being an analogous case, one part is that in one case is a case of a debt. Of course, the deceased was paying; he was an income taxpayer.
So you see, basically, you're not in dispute as far as the facts are concerned.
Basically,
And let's put it this way, even as far as the entitlement is concerned.
entitlement is concerned.
So your only grievance would be on the quantum
Basically.
vis-a-vis the interest.
Interest, principally on the interest.
And that is also based on the premise that the matter has been delayed substantially by the conduct of the respondent claimant.
Yes.
So that is your.
And to that effect, we had filed a list of dates by both the parties. My lord can peruse the order accordingly, that who is attributable exactly. So from
Have
that
you also cited any relevant authority?
my lord, so far the interest is concerned, in fact,
No, on the point of delay, there should be some authority.
basically, my lord, so far the delay is concerned is what happens is that the matter basically the interest portions are.
Exactly, but you see now, Mr. Khan.
I'll supply now because there are some.
Now there must be some.
There are.
Even for Ms. Bhattacharjee here.
Yes.
On your part also, you should enlighten this court, or rather, assist the court in as much as bring some relevant point on this regard. Because basically, I think that would be only the only issue to be decided. So what perhaps either some other high court or Supreme Court must have decided as to how the delay can be can have an impact.
Yes, yes, and definitely.
in the in the subject matter.
But
So
since
to
there's
that
a
extent,
delay of
can-
17 years, and then
Yes, yes.
in fact, will substantiate. Yeah, in fact, there are quite many. So I thought more or less that will substantiate. I'll supply them.
Well, the court doesn't need as many as 20 or 30 judgments.
No, no.
What only relevant
What is the relevant?
What is relevant to
What
the
is relevant?
subject matter. So how soon can you do it?
Just 2 weeks maximum.
You are the appellant.
Well, I'm the appellant.
Letter counsel, Mr. Ikhan, letter counsel for the appellant has submitted that the written argument has been filed. However, it is further submitted that the parties may be allowed to file relevant authorities to substantiate the points urged before this court. On premiere, this is met after 2 weeks.
Item number 13.
My lord, in this case, having little difficulties, but I was thinking to take leave from the court to resign myself from conducting this matter, because I have tried whatever I can to assist the court and also to help the client. It seems the client
He's not coming back.
He's not coming back. He's not responding. In fact, I have requested the court.
What are his routes as far as this place is concerned? Any connection, marriage, this, that, or employment, or
In India?
yeah, particularly Shillong?
But in Shillong, in Shillong, my lord, he doesn't have any roots, but he was a student in Pune, and he was some international tourism kind of this thing. And then he came here to volunteer as a student volunteer with some organizations and all. That is the only thing, oh my lord. And then even in the trial courts, my lord, I have requested the court to issue a notice, a summon to the bailers, because I can't. It will be unfair on my part to stretch from dates to dates unnecessarily, my lord, wasting court's time also. And in fact, I have I wanted to mail him and inform him that I can't argue for him or represent him anymore in this matter, because if the conduct of the client is such, with I've done.
So
Yes.
what do you do, Mr. Yubin?
My lord.
In such a situation,
My lord.
You see, if the petitioner is not keen to prosecute the matter,
My lord.
so he has to be informed accordingly. Number one,
Yes, my lord.
it is duty is cast upon you to. You are his counsel.
My lord.
You should inform him that either he disengage you,
Yes,
or you withdraw the matter
my lord.
and leave it to his.
My lord, my lord. Give me just a week's time, my lord. I will do the whatever necessary steps that I need to do on my part as a counsel, my lord. Give me a week's time. I will, by then, my lord, some papers I will place. I will be on records. I'll be able to place, my lord.
Fine. On pre-bid ready. Let a counsel for the petitioner. This is matter after 1 week.
My lord. Obliged.
Second call from supplementary process. Item number 3.
Yes, Miss. Tell.
My lord. My lord, in view of the order passed by this honorable court, my lord, I must supply to the enquiry report. And my lord has seen the inquiry report, my lord. Thereafter, my lord, I filed a representation, my lord. My lord, the representation is at page 55, my lord, annexure 12.
Page
55, my lord.
yes.
My lord, in my representation, my lord, I have categorically stated, my lord, that
Yes.
that my lord, the jailer who was present at that point of time when the incident happened, my lord, he had been made an inquiry officer in these proceedings, my lord. My lord, may kindly see paragraph 3, my lord.
Yes.
May I read, my lord, paragraph 3, my lord? That in the instant case, the alleged inquiry report is nothing but it appears to have been created at the dictation of the disciplinary authority, and as such, the jailer of the district jail, Tura, at the relevant period of the escape, and it is the magisterial inquiry report also primarily reported that there was collective administrative lapses at the relevant time of the escape. Accordingly, the justice demands that the officer who is directly or indirectly responsible in the escape, or more particularly when the magisterial inquiry report also does not give any clean sheet to the then jailer of the district jail Tura, but just to cover up the administrative lapses, the disciplinary authority has most illegally appointed said jailer of the district jail Tura, who was at the relevant time jailer as inquiry officer of the instant disciplinary proceedings. Thereby, the very course of justice has been buttered and flattered, and thereby justice has been denied to the innocent petitioner, and thereby the interest of the delinquent has been highly prejudiced, my lord.
What is the meaning of buttered and flattered?
Thereby, exact meaning, my lord.
Can you tell me? See, I'm very interested in the English language as such. Any words? I will try to find out. In
flouted. It should be flouted. Well, it's like,
56.
buttered and flouted. Flouted, I am a little unsure whether the English language would have any such word as flouted. I was under the impression it could be probably fluttered.
Flouted, fluttered, flattered.
Flouted could be, Malits. Lordship, just permit me a second, Malits. I could take the assistance of Google probably to assist your Lordships.
Don't tell me you'll come with some Italian phrase.
There's no such word as flouted. There seems to be some typographical error.
But what is buttered?
I would have to leave it to the ingenuity of the author of the letter.
It could have been butchered. It looks like.
Probably that was.
Is it you're emphasizing on these words?
Buttered and flouted.
To show that the whole proceeding was, flawed.
My lord.
Flawed.
You put the code in a very difficult.
But there is an observation by this honorable court, my lord, how the jailer who was the jailer at that point of time can be an inquiry officer in these proceedings, my lord.
That would be a mean.
My lord.
I think that would also be the concern of the court.
My lord.
Nobody can be. They say nobody can be a judge in his own case.
My lord, and it's a settled law, my lord. The witness who is the witness in a in misconduct, my lord, cannot be a inquiry officer in that proceedings, my lord.
Yes, he should. He would also be a.
Lord, it will be amount of biasness, like my lord.
What do you say, Mr. Khan, on this?
Lordship.
I think the whole focal point would be on this, and the fate of this case, or rather the fate of the petition, would hinge on this.
Lordship,
You have initiated an inquiry. Fine.
Lordship, it's a very valid question that has fallen, but as Lordship is aware that any such situation, if it presents itself, what is the first option for anybody who's aggrieved? Lordship, allow me to just formulate that question. What is the first situation that presents to the delinquent or person who's aggrieved? Either he immediately shoots down a letter to the immediately high authority or to the concerned authority in the proceeding. If the case was that he or she was not present and the proceeding went on ex parte, then maybe this question is very, very relevant.
Oh, see, Mr. Khan, whatever the case may be,
but
forget about this. See, subsequent events. The fact is that
Lordship,
even any right direction would not undo the wrong that was perpetrated.
Lordship, I completely agree. I completely agree with the Lordship. But Lordship, what I'm trying to submit is that if the delinquent was aware of the officer who was conducting it, my first submission, Lordship, would be if he or she has not presented an objection, if that was overruled, then the option was to go to high authority. Now, if this two situation was not undertaken by them, in other words, it would mean they have waived it. Lordship, that is my first argument. Second, even for the sake of argument, they have to read out the evidence, and still show he acted in a biasness, or certain things were supposed to be done, he did not do it, and certain things they presented, which he ought to have considered, that was overlooked, thereby causing prejudice. So here, Lordship, there are two principles at play. They have waived it, and then they have to justify that even if they would have not waived it, supposing what has fallen from your Lordship, they have to justify how it has caused prejudice. Because his conduct of prejudice is crucial. If both things are not relevant.
But even from the inquiry report, you find that there was no elaborate discussion on the evidence,
finding on the
except for that one.
We have, Lordship, have the report. The deposition has been recorded. Lordship, that is again a very, very finer point of argument why I am submitting this, Lordship. Lordship has done a number of cases. In a situation where, Lordship will kindly appreciate, in a situation where inquiry is done, it's an admitted fact. That they participated. At this stage, all three of us will be in the same page. The moment it goes to the next stage where certain things, they should have been given a fair chance for putting certain things. There should have been a chance to adduce the documents, and that should all come in form of a letter or a record. If those things they had presented and that were overlooked, and the consequences of overlooked, Lordship is very aware, is that they had caused prejudice. If those situations are present in a Lordship can set the clock back. And in this case, Lordship will kindly see till the last order, this court's order where the report was given. Till that point, Lordship, I am in complete agreement that there were serious lapses. Report was not given, second show cause was these things, and they had to come to court a number of times. Nobody is denying it. But then our case starts only, Lordship, when the court passes an order on an inquiry report. And they get the report. Lordship will kindly appreciate. Then the principle of waiver, acquiescence, these are principles because they have the benefit of that. If they keep quiet, means they are not prejudiced. If certain documents ought to have been considered, then they are prejudiced. And Lordship, I read that part. Again, I'm just trying to be very specific on that part. That part where the opportunity was given to participate and prosecution witness was let, defense witness was called upon, defense counsel was called upon, and in that finding, Lordship, in that inquiry report finding, they have not also mentioned in the when the early order was passed before the court that because of this reason, had there been a case that non-receipt of inquiry is one part, the inquiry itself is flawed because of these were the objection that we have raised. So their objection part is missing in all the earlier orders.
Okay. This court will hear you. Let the.
Lordship, I'm just trying to clarify in the presenting officer part.
Just the departure from the.
Absolutely.
No,
Lordship.
the
That was a very
amendment-
valid question, Lordship raises. Because if that question is answered against me, then the whole case goes.
Exactly. Now, please
My lord,
continue.
thereafter comes, my lord, the final order by which I have been removed, my lord. Page 66, my lord, the annexure 13.
Yes.
My lord has seen that there is a direction to give a proper explanation as to why the jailer has been made the inquiry officer, my lord, by this honorable court, and that has to be, my lord,
Where is that reference?
that reference is at page 48, my lord. Page 48, my lord, and the last paragraph 6, my lord. May I read, my lord? Before parting with the records, this court with serious concern notes that when from the magisterial enquiry report it is manifest that there was a collective lapse which enabled the prisoners to flee from the prison, how the jailer who was in charge of the jail at that time was made the enquiry officer requires to be answered by the disciplinary authority before passing the final order, my lord. And my lord may kindly see the final order, that is at page 66, my lord.
Yes.
There is no explanation to that effect, my lord. The final order.
Yes.
The final order is totally based on the magisterial enquiry, my lord.
Yes.
And last paragraph, my lord. After careful examination of the magisterial enquiry report and the report of the enquiry officer, it is clear that the charge of negligence and dereliction of duty has been proved against ex-warder Sri Ashrafi Lal Singh. I therefore award him the major penalty of removal from service. The period of suspension is to be treated as not on duty. He will be entitled only to subsistence allowance during the period of suspension. He has been awarded with major penalty, my lord. And nothing has been explained as to why, my lord, the jailer has been made the enquiry officer.
Yes.
My lord, thereafter, my lord, I filed an appeal before the appellate authority. That is at page 68, my lord. And the appellate authority has passed the order, my lord, that is at page 90.
Yes.
My lord, may kindly come to page 92, my lord. May I read, my lord, the entire orders?
Page 90 is the order.
Yes, my lord, the page 90 is the order.
Yes.
May I read the entire order, my lord?
Please.
Seeing the order of the Honorable High Court in WPC so-and-so in case of so-and-so has filed the appeal petition under section 13 of the Assam Service Discipline Appeal Rules 19, it should be in 64, my lord, against the order number so-and-so dated 12/4/2012 passed by the Director General of Prisons, Meghalaya, Shillong, imposing the order of removal from service. As per the High Court's order dated 19/11/2013, I shall proceed to consider the appeal of so-and-so during the personal hearing of the appellant stated that he had nothing more to add than what he has been submitted in the appeal petition. The disciplinary proceedings was drawn up against the appellant on 1/2001 with the following article of charges framed against him on the statement of allegation. These are the two charges, my lord. And then, my lord, and next paragraph, my lord, the inquiry was held into the allegations, and the inquiry officer on the first article of charge, the IO found that the appellant did not exert utmost vigilance to prevent the escape of the prisoners, and thus failed to discharge his responsibilities. The IO also found that the appellant did not exert any vigilance worth its name and failed to make use of the peeping window. The IO also stated that appellant could have used the attached toilet, which is in the main gate and office room itself, even without being relieved by anyone who the so-called call of nature was so accident in character. The absence of the appellant for a few minutes would not make any difference if he leaves his post after securely locking the gate. The IO also found that the other charges against the appellant, that he opened the inner gate of the jail to call one of the warders inside the jail and thereby facilitating the prisoners to snatch the bunch of keys, open the outer gate and flee, as proved beyond doubt on the ground that there are many alternative means to communicate with a person inside the jail. The gap between the two iron doors of the inner gate could also be used to communicate with the prisoners, to call the warders on duty to relieve the appellant without opening the inner wicket door at all. The IO thus found the second charge on negligence as proved beyond reasonable doubt. By an order dated 13/9/2007, the disciplinary authority issued the order of removal from service after considering the inquiry report and the statement of defense. The first appeal petition of so-and-so before CNS prisons was disposed of by order dated 9/2/2009. Subsequently, the Director General of Prisons, by order dated 12/4/2012, and also considering the inquiry report of the Tura Magisterial Inquiry Report and other records, upheld the charge of dereliction on duty and awarded the appellant the major penalty of removal from service. The appellant has cited several procedural grounds for consideration of his appeal, but the basic ground of appeal cited by the appellant is against his action of opening the inner gate, resulting in his being overpowered by prisons and their escape. On the basic ground of appeal, the appellant has stated that he could not have failed the presence of the 27 inmates of the jail near the inner gate, and that he could not have used the window to see if any inmates assembled by the side of the inner gate, as through the window only straight view could be seen and side views is not possible, and hence the inquiry officer is totally wrong to hold that the appellant did not exert utmost vigilance to prevent the escape of prisoners. Secondly, the appellant also stated that he could not have used the attached toilet, which is in the main gate and office room, as they were out of condition, and hence he made all attempts to call the inside duty staff to relieve him due to the call of nature. When none turned up, the appellant opened the inner gate to call other duty staff of the jail, as which time the appellant was attacked and prisoners snatched his key and fled from the jail. The appellant also submitted other grounds for appeal, such as IO refusal to cross-examine a single witness and non-furnishing of certain records, letters and memos by the IO to the appellant, besides delay in conducting the inquiry. After going through the records, I have find from the reports of the magistrate inquiry that gross negligence and carelessness by opening the inner gate by the appellant led to escape of prisoners with no plausible reasons and accounts for the dereliction of duty by the appellant. While the appellant was on duty as gatekeeper, the magistrate inquiry also conclude that he had not been for the unforgivable mistake of the appellant, the entire situation would have been saved, and therefore he is responsible for the escape of prisons on 18/11 to 1999. The magistrate also indicated that since the incidents of same modus operandi being second in his time on duty in the gate is a mistake that cannot be taken for granted, the appellant is not a person to be trusted anymore.
Lordship, just pause for a minute before we conclude. The magistrate inquiry report says this is the second time. Just to apprise the court on that.
Yeah, you can.
The second time the jailbreak.
You can point it out.
Sorry, Lordship, just to point.
From the IO's
Why would you want to emphasize on it?
Let me escape.
From the IO's findings and other records, it is thus evident that the escape of the prisoners on 18/11/1999 from District Jail Tura was primarily because the appellant opened the inner gate, resulting in his being overpowered by the prisoners and their escape. Both inquiry officer reports and magisterial inquiry pointed to the fact that appellant with sufficient experience as gatekeeper failed to exert utmost vigilance and negligence in the discharge of his duty as gatekeeper by opening the inner gate. As an experienced gatekeeper, he could have well understood the dangers of such an action. His argument that the toilet switch is in the main gate and office rooms itself were out of order and could not be used cannot be taken on face value. Moreover, he could have used the gaps between the two iron doors to communicate with the prisoners to call the warder. While examining the records of inquiry, I find that IO has given the appellant sufficient opportunity to be heard and also to defend himself. The procedures prescribed in the disciplinary rules have in main been complied with, and appellant has been given sufficient opportunity to defend himself on the allegations and show cause notices. While examining the records of inquiry, I find that the IO has given his findings on the statement of allegations and not specifically on the article of charge, with the result that his findings are not specific as to each article as they could be. Even so, no material irregularity has been committed by the IO and no injustice has been done to the appellant. There is no evidence of bias on the part of any authority concerned. Given the facts and circumstances of the case, the penalty of the removal imposed on the appellant is appropriate. Therefore, I find no reason to interfere with the order dated 12/4/2012 of the Director General of Prisons. The appeal petition is accordingly dismissed. My Lord, may kindly see the last paragraph, my Lord.
Yes.
May I read again, my Lord, the last paragraph? While examining the records of inquiry, I find that the IO has given his findings on the statement of allegations and not specifically on the article of charge. My Lord, they themselves admit that there is no specific findings on the article of charge, my Lord.
But of course, he said that this will not vitiate the proceedings as such. It is, for you to point out it is otherwise.
My Lord, there has to be a specific finding, my Lord, and in the inquiry report it has to be reflected, my Lord, on what documentary evidence, what have been done in like entire proceeding, that has to be mentioned in the inquiry report, my Lord. Nothing has been mentioned in the inquiry, and my Lord has seen.
Yes.
My Lord, I will be relying on this Assam Service and Discipline Appeal Rules 1964, my Lord. My Lord, may kindly come to Rule 9, my Lord.
Yes, ma'am. Yes. Rule?
Rule 9, my lord. Rule 9. Sub-rule 7, my lord. Imposition of measure.
Procedure for imposing penalty.
Procedure for imposing penalties, my lord. Rule 9, sub-rule 7, my lord.
Yes.
My lord has got it, my lord. Rule 7. At the conclusion of the enquiry, my lord, the enquiry authority shall prepare a report of the enquiry recording its findings on each of the charge together with reasons therefor. It is categorically mentioned that there has to be reasons and findings on each of the charges, my lord.
Okay. Please go.
Now, my lord, I have concluded my hearing, my lord. My lord, for
Yes, anything else? Any authority?
I am assisting my learned friend bullets.
You speak true, huh? He's doing very well.
Lordship, I told her also yesterday. After we left the courtroom, I said, you're doing very well.
my lord, I'm relying on this 1969 2 SCC 262, my lord. Not 60, no, it's 1969.
262.
262, my lord.
Para?
Para 15, my lord.
Yes. Yes, what would you like to point out?
Lord, the book is not with me, my lord. My lord, give me some time, my lord. In the meantime, my lord, the senior.
Court has got the book.
My lord,
But you have to read the.
There's a paragraph. Which paragraph you want to read?
it's not there.
No, what you should have done is when you're relying on any authority, at least an advance,
My lord, sorry, my lord.
It's available. In our times, well, we were taught otherwise. Probably we will not be able to pass it on to them.
When we say that we have to be prepared, mean prepared. What is the essence of this?
On the ground of natural justice, my lord.
Paragraph 13 to the court. Take the court, page 268.
My lord, it's page 268, my lord. Para 13, my lord. May I read, my lord, from para 13, my lord?
Please.
The dividing line between an administrative power and a quasi-judicial power is quite thin and is being gradually obliterated. For determining whether a power is an administrative power or a quasi-judicial power, one has to look to the nature of the power conferred, the person or persons on whom it is conferred, the framework of the law conferring that power, the consequences ensuing from the exercise of that power, and manner in which that power is expected to be exercised. Under our constitution, the rule of law pervades over the entire field of administration. Every organ of the state under our constitution is regulated and controlled by the rule of law. In a welfare state like ours, it is inevitable that the jurisdiction of the administrative bodies is increasing at a rapid rate. The concept of rule of law would lose its vitality if the instrumentalities of the state are not charged with the duty of discharging their functions in a fair and just manner. The requirement of acting judicially in essence is nothing but a requirement to act justly and fairly and not arbitrarily or capriciously. The procedures which are considered inherent in the exercise of judicial power are merely those which facilitate, if not ensure a just and fair decision. In recent years, the concept of quasi-judicial power has been undergoing a radical change. What is considered as an administrative power some years back is now being considered as a quasi-judicial power. Thereafter, my lord, the discussions on law, my lord. My lord, may kindly come to para 20, my lord.
20?
20, my lord.
Yes.
The aim of the rules of natural justice is to secure justice, or to put it negatively, to prevent miscarriage of justice. These rules can operate only in areas not covered by any law validly made. In other words, they do not supplant the law of the land but supplement it. The concept of natural justice has undergone a great deal of change in recent years. In the past, it was thought that it included just two rules, namely, no one shall be judged in his own case, and number two, no decision shall be given against a party without affording him a reasonable hearing. Very soon thereafter, a third rule was envisaged, and that is that quasi-judicial enquiries must be held in good faith, without bias, and not arbitrarily or unreasonably. But in the course of years, many more subsidiary rules came to be added to the rules of natural justice. Till very recently, it was the opinion of the court that unless the authority concerned was required by the law under which it functioned to act judicially, that there was no room for the application of rules of natural justice. The validity of that limitation is now questioned. If the purpose of the rule of natural justice is to prevent miscarriage of justice, one fails to see why those rules should be made inapplicable to administrative enquiries. Oftentimes, it is not easy to draw the line that demarcates administrative enquiries from quasi-judicial enquiries. Enquiries which were considered administrative at one time are now being considered as quasi-judicial in character, arriving at a just decision is the aim of both quasi-judicial enquiries as well as administrative enquiries. An unjust decision in an administrative enquiry may have more far-reaching effect than a decision in a quasi-judicial enquiry. My lord, these departmental proceedings are they are quasi-judicial in nature, my lord. So, my lord, and for that reason, my lord, the court has to the disciplinary authority has to act as a judicious mind, my lord. They have to go as per the act as my lord. They must act impartially, my lord.
So the issue of good faith comes in the picture.
These proceedings are not an empty formality, my lord. They have the procedure, whatever has been prescribed under the law, that has to be followed, my lord. And my lord, since the jailer is the inquiry officer, my lord, it will amount to, my lord, a biasness, my lord. And my lord has seen from this judgment that my lord, that no one shall be a judge in his own case, my lord, and then it will be a violation of the natural justice, my lord.
See, but what has been countered by the respondent is why you have not made any objection at the initial stage, because the inquiry officer would have interacted with you.
My lord, the inquiry officer, my lord, during the entire proceedings, 3 times, my lord, the inquiry officer has been changed, my lord, and there is no proper justification why the inquiry officer has been changed 3 times, my lord.
Whatever the case may be, see, the inquiry officer who has finally conducted the inquiry would have interacted with you, would have got the witnesses examined in your presence, allowed you to cross-examine, and you know him very well. He is the jailer of the particular jail. If there's an aspersion of bias or lack of good faith, you should have pointed out. It's incumbent upon you to do that.
My lord, my submission is, my lord, I have already stated in the writ petition, my lord, I have never been called also, my lord, during the entire proceedings. No list of witness has been given to me. No, my statement has not been recorded, my lord.
Oh, is that so?
My lord.
Do you have the records, Mr. Khan? So we have to produce the record.
That's why that's why in the middle of hearing I wanted to.
Paragraph 18, my lord, of the writ petition, my lord.
Read directly to the court.
this is your grievance against the, the inquiry officer being the jailer.
My lord.
But
My lord, here I have stated, my lord, that no statement of witnesses, no documentary evidence has been produced or taken into consideration while coming into the conclusion of the charges against the petitioner.
no, that is a different issue altogether.
What is there?
The query was, as stated by you, no witnesses have been examined in your presence. You have not been called before the inquiry officer. You substantiate that, or rather, the records would, would prove that.
My lord, paragraph 5, my lord. It is pertinent to mention herein that the respondent authority, while issuing the letter dated so and so, did not furnish to the petitioner any statement forming the article of charge as required by procedure, and neither a list of documents nor list of witnesses by which each of article of charges was proposed to be sustained was supplied. And to this paragraph, my lord, the state has filed, my lord, as per the state's affidavit, my lord. My lord, we kindly come to the affidavit filed by the state, my lord.
Yes.
Page 2, my lord, paragraph 9.
Paragraph?
Para 9, my lord. With regard to the...
Para 9. Page 3. Yes.
With regard to the amendments made in paragraph 5 of the writ petition, the answering respondent states that the explanation submitted by the petitioner on 33/2001 is found not satisfactory, and as such, the disciplinary authority served him with the second show cause notice. They have not denied, my lord, that I have not. They have supplied any copies or any list of witnesses, my lord.
Yes. Anything else?
My lord, I am relying in one more citation, my lord, that is 1964, volume 3.
1964,
volume 3, SCR, my lord, page 652, my lord. At page 653, my lord.
653.
3.
653.
Second paragraph, held.
These are notes.
No, my lord. Paragraph. My lord, 659, my lord. Yes, here. This one.
Page 659.
Plus, sorry, 660, my lord. 660. The last part, my lord, of the paragraph.
660.
My lord.
Yes.
My lord, the last line of the paragraph, my lord, starts with "we are inclined to think that."
Yes, only.
My lord has got it, my lord.
Six 660, isn't it?
My lord.
Last line.
Last line. We are inclined to think that, my lord.
What is it?
In the middle, from the middle, my lord. I'm reading this.
First you say last line, now you say middle. We are inclined, please.
We are inclined to think that the injustice which is likely to result if a domestic inquiry is held by an officer who has himself witnessed the alleged incident, my lord, is very eloquently illustrated by the statement contained in the manager's letter to so and so. That is why we think it is desirable that conduct of domestic inquiry should be left to such officers of the employer who are not likely to import their personal knowledge into the proceedings which they are holding as inquiry officers. In my case also, my lord, the jailer has witnessed the incident.
Done.
Let him respond, my lord. Let his senior respond.
Mr. Khan, today or tomorrow?
Up to you, Lordship, up to you.
Or after lunch, it's up to you.
Whenever Lordship says that, we understand looking at the time.
Yeah, now
Anything,
it's, we have to recess. Huh?
Absolutely, Lordship, tomorrow.
Or tomorrow waiting here.
My lord, whatever my lord senior submits to that, I'll submit.
Yes, yes, you are allowed to. On law points. Heard then the counsel for the petitioner. The reply of the respondent will be heard on the next date fix. This is matter to 1 week. So we'll hear it after 1 week.
Oh, sure.
I would probably submit my friend here, who she's argued the matter, would need to polish her arguments and place it in a more concise manner on your lordships on the next day.
No, what you can do is, you see, you have noticed how this could proceed. An opportunity is always given to the parties to file their written argument. So there you can put it in proper, more concise form. More. So you have done very well. So we then.
Absolutely.
Completely costless. Item number 3.
Number. Hello. Sure. Agani. Yes, Mr. Sama, what do we do?
Yes, I'm ready, but Lordship may like to go to lunch.
Today or tomorrow or
This is 2016 matter, Mano. You can take in the second half also, Mano. Lordship is willing.
Other people there, if they're ready, I have no problem to come.
You are for
I'm for the respondent, Mano.
respondent,
Private respondent number 4, 6 and 7, Mano.
and who is there for the?
JCDC.
There's also the district council.
Lordship.
Who is appearing? Yes. So you're ready? So we'll take it second half.
Lordship.
Yes.
Mr. SD has some of the Your Lordship that it will pass for tomorrow, Your Lordship.
Lordship actually has heard this matter in length. This is pertaining to the Nokmaship, my lord, wherein they are challenging the order passed
CEM
by the CEM, my lord, in a review. In a review petition, my lord. Now, last occasion, Lordship was pleased to hear the matter and to remand it back because Lordship found that the order of the review is illegal, as well as the order of the earlier order passed by the CM. That was the only case, my lord.
So, matter was remanded?
No, the matter was supposed to be remanded back, but by the time we came to know that an ex-parte order was not passed against the respondent number 5.
No, that order is there also. Because there was an order, Lordship.
Ex-parte order has been passed by this honorable court, my lord.
Was it that without attendance of the respondent number 5, that case can be proceed as
Okay. So, who's the respondent 5?
Respondent 5, none has appeared, my lord, and ex-parte has been proceeded against him. Yes.
It is in the order also, is reflected.
It has been reflected in the order itself, my lord.
Oh, so what remains now?
Actually,
is it the consensus of the parties that the matter be remanded to the CM again?
Because Lordship, after hearing the parties, my lord, has come to a conclusion that the order passed in review is illegal. So as the order passed by the earlier CM, my lord, is illegal, my lord. So nothing remains because the same subject matter is pending before the executive member, my lord. So this matter can be tagged along with that matter, my lord, and it can be heard together.
It can be remanded. I don't have no objection because my learned friend also have stated there's an illegal order in the review petition. He himself admitted. Therefore, we have come against that order. So, and the same connected matter process, same that case is pending before this one.
How can the same matter be heard by simultaneously by EM and also before this court?
Yes.
Lordship, that is what I'm saying, my lord. That same subject matter is pending before EM, my lord.
Yes, I mean, how can it be?
But one thing is, Lordship, this petition actually it was little confusing type. Actually, first I was the first Nokma. I mean, just to narrate the story. First, I am the Nokma of that particular Akung, and I have been registered since from 2023. And respondent, my learned friend is appearing. They file an appeal against that order, and then High Court remand the matter. Again, there was order in my favor. Again, they come. There's a second round of litigation. Then, when they come back again, court has remanded the matter again. At that time, Lordship, another third party who were claiming that Ajiksi, they said that I said that Delmar Mtongri belongs to Ningmenja Akung. When the case is pending and that it has reached also here and the case has been remanded back to the EM for deciding the price, at the meantime, this third party, respondent number 4 and 5, they have claiming themselves that same Akung, that Delmar Mtongri is an Ajiksi Nokma, and they also said that we want to be the Nokma of that Ajiksi. So at that meantime, my people, one of the Tra, he filed a complaint to the CEM saying that this is the case where this respondent number 4 and 5 should have made a party because they are claiming in my land only, they are claiming that Delmar Mtongri is the Ajiksi Akung. It is not a Ningmenja Akung, but it is Ajiksi. So, order was dismissed. This is on record also. CEM dismissed that order saying that this case has been already settled long back. If you want, you can go to the High Court. Even in that order also is there. Even my learned friend has filed an additional appeal to that effect. They said there is a case, then it has been settled. You have been supporting this respondent number 4 and 5. You both of you have been supporting the appointment of my Nokmasip. Now again you are claiming for yourself that Ajiksi. Then against the order of 2015 it happened. This there also. This respondent number 4 and 5, particularly respondent number 4, he filed the revision petition before the Court of Chief Executive Member. chief executive member allow the petition and consider the case and allowing the respondent number 4 Nugan Sangmana to be the Nokma of the Rimtangri Ajiksi. Then against that order we have come and this is the case, Your Lordship. So actually that is the case. But actually, Lordship.
So here that means the respondent 4, you are respondent 4.
I'm appearing for respondent 4 as well, my lord.
And moreover, Your Lordship, he has been appearing for the respondent number 4, means they seem to be the third party, and as well as for the earlier where for the respondent.
Lordship, I'll just simplify what was my learned friend is trying to submit, my lord. Actually, this particular matter, my lord, this Akhang is actually a joint Nokmaship Akhang, my lord. So there are two clans in this particular Akhang, my lord. One is Nokma coming from a Mangsang clan and another for Ningmunja clan. He's claiming to be a Nokma of a Ningmunja clan. That matter is pending before executive VM. Actually, what should have happened? This matter, the entire matter should have been before executive member, my lord. But this matter has been segregated, my lord, into two halves. Now, what has happened, what has transpired? One Nokma for Mangsang clan, they have been agitating their issue, my lord. So, this respondent number 4 was declared to be a Nokma.
Of the Mangsang clan.
Of the Mangsang clan, my lord. Then thereafter, the executive, an appeal was filed, but by that time that EM who has passed an order in favor of respondent number 4, he was elevated to the post of CM, my lord. So he was not able to take up the matter. Then eventually what happened? They somehow filed an application saying that matter is pending before the executive member, which is in respect of Nangmunja clan. So this matter is not sustainable, it's not maintainable at all. So he being an appellate authority should have not entertained that matter, my lord. But he did entertain the matter. So that is why I'm saying that
against his own order.
Against his own order, that is what I'm saying, my lord. Then what happened? By that time, another CM was in his post, my lord. And we filed a review. So Lordship has rightly said, so that review is not maintainable. So a review was in my favor, my lord. They are aggrieved by the review and came before this honorable court. Now what I am submitting, my lord, is that review is also illegal, and that appeal which the CM has passed that is also illegal, my lord. So let this matter, that two orders be set aside, my lord, and let it be remanded back to the EM since the matter is still pending there sub judice, and let the EM decide on the entire genesis of the matter, my lord.
Okay, so that is as far as the principal parties involved here is concerned.
Yes, lord. Yes.
Now, what is the role of the district council here?
Because that
district council actually basically had to just support the order of the review CM or the review, my lord. But last occasion also, my learned friend has submitted that both the order is not sustainable. So lordship was supposed to remand back the matter. But meanwhile, it came to transpire that respondent number 5 was not.
Just to clarify that matter.
Lordship. So after it was clarified, Lordship passed an ex parte order against the respondent number 5. Now nothing remains, my lord.
What is the order written?
This is 7/12/2022.
It's 7/12/22, my lord.
7/12/2022.
Yes.
Parties we are conscious that we are agreed that let the matter go remand to the.
Both the order be set aside, my lord, and let it be tag along with that matter which is pending before the EM, so that they can agitate the issue there, my lord.
But Mr. D should have been here. We'll take it up tomorrow. Tell him to.
Lordship.
Because, now the code is clear.
Lordship.
There is no quarrel as, according to the
Lordship.
submission made by the parties.
Lordship.
That the matter may be to be demanded back.
Yes.
So if the district council has no objection to that, then
His last occasion
merit
also-
will not be touched. The matter will just be.
Otherwise, also, Your Lordship, we are
remanded.
the aggrieved person. Both of us are aggrieved person. We are the main person who are aggrieved. If we are agreed that later matter we go remand, because this
Exactly.
is a little complicated, and the district council actually they don't have a little role to play, because mainly we are the victims and we are
The
the
district council here would be the adjudicator.
yes only the adjudicator. If we are agreed that matter may be
His
remand
last
back.
occasion also, my lord, if Lordship could recall, my learned friend also made the same submission.
Yeah, but he is not here today. He
Yes,
should have been here. I saw him in the morning. What happened?
Yeah, he was here, my lord.
Urgent works, Your Lordship. So,
As it is, if without his presence of an order is passed also, my lord.
That would see.
Oh, Lordship. I'll leave it to
You
your
never know.
discretion.
Mr.
I'll leave it to your discretion.
For chance something comes up,
Lordship.
then
I'll leave
this
it to
plea will be raised, and then you'll jeopardize your own case.
Lordship. I'll leave it to your discretion.
But tomorrow one difficulty we have so many cases, and in the division bench also I have some cases that appeal is there, and some important.
So you suggest a
that's why
date. Suggest a date.
It's like Monday, next Monday. It is not because we
Monday.
don't want to do it, but only thing is that we have some difficulties also.
Okay, so Monday.
Monday, but if it may be recorded that further
Yes.
adjournment maybe not be.
Yes.
Yes,
my
it's
lord.
not actually.
But
not
you
proposed to
inform your colleague.
Yes, Monday.
Let him know.
We'll do it on Monday.
Now that prayer has been made on behalf of the Leonard Standing Council for the respondent, Standing Council GHADC, who is appearing on behalf of the respondents
1, 2, 3.
1, 2, and 3 on the ground of his personal indisposition before the court today. However, parties present are in agreement that this matter, though it may be adjourned today, the same may be heard definitely on the next date fix. As agreed to by the parties, let's this matter on 8 or 15th. 15, isn't it?
Lordship, Monday is 15.
yes, Your Lordship.
Yes, Monday is 15.
15 Monday.
Let's this matter on 15 for this is matter on 15.
Further adjournment may not be granted, my lord.
I've only
It is already there. Twice, thrice is there.
So you want me to get another 4 times?
Problem is not
Because
because
this matter is pending
intentionally.
since 2016, my lord.
That is why I see.
Yes, it's not intentionally, but due to some reason, Lordship,
Exactly.
it happened.
Now
We have no
that
intention
apart,
to
so
avoid
order,
the matter.
order has been passed.
Yes.
But in such cases, if the parties are in agreement on some point,
Yes.
you should have made a submission before the court. Soon after.
Yes, yes.
Then the matter could have been sent back, and by now maybe some another
Yes.
another petition would have been filed. So it goes on.
Yes, yes.
But then keeping the matter pending for so long
Yes.
makes no.
On that day, that we'll keep in mind that we'll not have any objection, but let the matter remand back to the.
Since the court is also clear that there is effectively no quarrel as far as the merits of the case is concerned, so it will just be remanded, and the trial court the trial court can take care of it.
Yes,
Lots
yes,
of-
yes, yes, yes.
I'll leave it.
Much blessed, Lordship.